Good morning, Meredith.
Hi, Bronson.
Can you hear and see us?
How are you?
I'm doing well. How are you doing today?
Good. Hi, AJ.
Yes.
All right, let's see if I can pass you the controls here. Make host. Okay. We'll just give everybody till 10, and then I will introduce everybody and we'll go from there.
Sounds good. It doesn't seem like I have screen sharing capabilities. Meredith, were you able to?
Yeah, I made you host.
Hmm,
Maybe give it a second.
sure.
Work during our test run.
Hmm.
Perhaps I'm the host.
Oh, that could be. Why would that be?
Do you have to select particular people who you shared?
I did it under AJ's. Yeah, see if you can share your screen. Oh, there we go. Is that you, Bronson?
That is AJ.
Oh, that's AJ. Oh, okay. Yeah, maybe it just took a second. Yay.
Let's see. So I don't know, AJ, do you want to control everything or do you prefer I do it on my end?
If I can
It's like
pass it to you, if that's convenient. If not,
don't seem to be able to control your screen from my side. I know that is a possibility, but if it's easier, maybe Meredith can instead share the power with me to share screen, but whatever's easiest. If you want to do it, AJ, that's fine. Just I know that I'm going to be starting off, so I don't know
right?
if it'd be easier if
Who's sharing the screen? AJ, you're not doing it?
that is AJ.
Yeah, yeah, yeah.
Is it possible
Okay, okay.
to
Got
give that power to Bronson since he's starting off?
I can try. I think I have to take it back. Let's see. That. I want to take it back. I could take it back during our.
By chance, can you hear that car alarm in the background, Meredith?
No.
Okay, okay, that's good.
AJ, is there a way for you to get it back to me?
Um, Stop share. You should have it back.
Let's see here. All right, now we want to give it to Bronson.
Yeah, if possible.
Annoying. Let's see here. Post. Okay, here we go. There we go. All right. Now let's try to give it to Bronson. A coast. There we go.
All right.
Okay.
Excuse me.
As your host, so it must be so. Okay. Looks like people are starting to come in.
Well, they're making it harder to get, so this one. I think we bought it.
Okay, great. All right, so good morning, everybody. Everybody is muted, and a lot of you, maybe all of you, were at the virtual seminar on the 14th with Dennis McRoberts and all of his great information. Now this is the second portion with the attorneys, free legal advice. So everybody pay attention. Bronson and AJ are from Battaglia Decoding. They are estate attorneys and experts in special needs trusts. So they'll have a lot of really good information. And I'm going to let Bronson and AJ take it away, and then we can talk a little bit about when they discuss the Special Needs Trust Foundation, about how it works and how you can submit a joinder agreement. So that is what I have for now. It's all you, take it away.
Wonderful. Thank you, Meredith. All right. Good morning, everyone. AJ and I are very pleased to present to you today. We're going to start with covering topics of general estate planning and conservatorships. Then we'll provide an overview of public benefits programs, including important updates. And then we'll jump into special needs trusts, and then conclude with ABLE Act accounts and TrueLink cards. So estate planning is essentially the process of putting one's personal and financial affairs in order. Having a complete estate plan can help you feel more confident about the future and that your loved ones will be taken care of. It can help you achieve a variety of goals and objectives, such as providing support and financial stability for you and your spouse, particularly in your later years, preserving assets for your loved ones, ensuring that there are resources and support for your minor children or family members with disabilities. Having a revocable living trust will avoid probate when you pass away. A trust can also minimize various taxes and expenses. Having a strategy for providing gifts to charitable organizations that matter to you, and ensure that you have a support system and that your wishes are carried out in the event of your incapacity. But estate planning can be challenging. Some people are a bit reluctant to begin the process because it forces them to think about their death. And planning may be especially difficult for those who have to decide how to provide for minor children or beneficiaries with disabilities, or perhaps even beneficiaries who have substance abuse issues or creditor problems or marital obligations. If you don't have an estate plan in place, well, when you pass away, your estate may have to go through probate and be supervised by the court. If you don't have a will or trust, your estate will be distributed according to intestacy laws, which mean that your assets may not go to whom or how you would have wanted. Your assets would go to your heirs at law, which are essentially your closest living relatives, in shares determined by the degree of relationship. If you don't have a plan for your potential incapacity, then a conservatorship may be needed so that someone can make financial and healthcare decisions for you. And a guardian for your minor children may be appointed by the court. Your conservator and guardian may not be who you would have wanted to make decisions for you or to care for your minor children. If the heirs to your estate are minors, they will receive their inheritance at, when they turn 18. And for many people, receiving a large sum of money at such a young age, may not pan out too well. And, an outright inheritance may also jeopardize an individual's eligibility for needs-based public benefit programs such as SSI, Supplemental Security Income, and Medi-Cal, which we'll talk about more in a minute. So what is probate? Probate is essentially the court-supervised process of wrapping up one's estate. It's generally a long process, minimum 8 to 10 months, oftentimes longer, and can be, quite expensive. Just the administrator and attorney fees, which are set by state law and calculated as a percentage of the estate value, adds up pretty quickly. The median home price in California now is, around $1 million. So even if an estate just had, a piece of real property of $1 million, the attorney fees and administrator fees are calculated as, 4% of the first 100,000, 3% of the next 100,000, 2% of the next 800,000. So it's just simply with a $1 million estate, you're looking at, $23,000 in fees for both the administrator and the attorney. So that's $46,000. That doesn't include all the costs involved in the probate. So it can add up pretty quickly. Also, a probate involves public filings. So there's no privacy with wrapping up your estate. When you initiate a probate, the proposed administrator has to publish notice of the probate in a newspaper, which gives constructive notice to anyone who might be, interested in the estate. In California, probate is required for estates that are valued at over $184,500. For estates that are less than that value, you can oftentimes avoid probate by using what we call small estate procedures. Typically, it's the successors in interest providing a third-party custodian who has access or holds the assets with a small estate affidavit. But otherwise, you're looking at a probate, which again can be very time-consuming and expensive. So what's in a general estate plan? Typically includes a revocable living trust, a will, which we call a pour of a will, a financial durable power of attorney, an advanced healthcare directive, and other related documents, which oftentimes include a nomination of guardian for minor children, a certification of trust to assist when dealing with third parties, one or more assignment documents, whether that be just a general assignment or an assignment of like a corporate or LLC interest, a schedule of assets, and sometimes a special needs trust. A revocable living trust is essentially an agreement for which someone manages assets for the beneficiary. The settlor, also called a grantor or trustor, is the person who creates the trust and retains certain rights and powers, such as being able to modify the trust, to direct and approve actions of the trustee, and to determine who serves as trustee. A beneficiary is someone who is entitled to receive income or assets from the trust. A beneficiary can be an individual or an entity, such as a special needs trust. The trustee is someone who has the authority to manage the trust assets and has the duty to carry out the terms of the trust. The trustee owes a fiduciary duty to both the trust estate and the beneficiaries of the trust. Typically, the settlor serves as the initial trustee of the trust, and a revocable living trust, as the name implies, can be amended or revoked by the settlor and becomes irrevocable upon the death of the settlor. An estate plan allows you to determine how you wish your assets to be distributed. You can simply provide gifts outright without any conditions or requirements, or you can have one's inheritance held in trust and provide that distributions be made at certain milestones or triggering events, such as when the beneficiary reaches a particular age or perhaps obtains a certain education. Or if you have a loved one with disabilities, you can direct distributions to a special needs trust. When you have a revocable living trust, you should still have a will, but it's a fairly simple version that we refer to as a pour of a will. So a trust will avoid probate when transferring assets after death, but it only covers assets that get funded into the trust. So if you think, I like to think of a trust as like a bucket. You want to get everything you own into this bucket so that you can control what happens to everything when you pass away. If for some reason, you didn't get some assets funded into your trust during your lifetime as intended, The pour of a will acts as a safety net to pour those assets into your trust. Now, while it's a safety net, the main downside of having to utilize a will is that you must go through probate. And this may force the administration of the trust to go on for much longer. So sometimes people go through all the effort of preparing their estate plan and establishing a trust, but then forget to fund their trust. So it's a very important aspect of establishing your revocable living trust is to fund the trust afterwards. So as the average lifespan increases, the possibility of becoming incapacitated at some point also increases. So a comprehensive estate plan, should therefore include arrangements for financial and healthcare decisions in the event of your incapacity. With a durable power of attorney, you designate an agent to handle your financial affairs in the event that you are incapable of making decisions for yourself. A power of attorney typically authorizes the agent to engage in all types of transactions relating to your property and financial affairs. So while the trustee of a trust has authority over all trust assets, there may be assets, accounts, or other financial affairs that are outside of the trust for which your agent under a power of attorney would be able to manage. So oftentimes people who, they will designate the same individuals who are named as successor trustees in the trust to be their agents under the power of attorney, so that those individuals will be able to manage all of the principal's financial affairs, both inside and outside of the trust. So similar to a financial durable power of attorney, an advanced healthcare directive allows you to designate an agent to make healthcare decisions for you in the event that you are unable to make decisions for yourself. An advanced healthcare directive will authorize your agent to communicate with and receive information from your healthcare providers. The healthcare directive can provide directions or limitations regarding specific treatment, such as the agent's authority to withhold or withdraw life-sustaining treatment in particular situations, such as if you're in an irreversible coma or vegetative state or some other prognosis for which your doctors don't think you have a likelihood of recovering from. You can also express your desires regarding, the disposition of your remains, organ donation, burial, cremation, or other wishes regarding celebration of life. A guardianship is a temporary arrangement through which a court-appointed guardian is allowed to make decisions regarding your minor child's care, custody, and education. With a nomination of guardian, you can designate who you'd like to care for your minor children if you're unable to do so yourself. So a nomination does not by itself create a guardianship, but will inform the court of your wishes. And while not binding on the court looks to what's in the best interest of the child and usually gives great deference to what the parents would have wanted when determining what's in the child's best interest. And so as you might imagine, a guardianship typically terminates when the child turns 18. A conservatorship is similar to a guardianship, except that it pertains to an adult rather than a minor child. And there are essentially two main types of conservatorships. Refer to it as a conservatorship of the person and a conservatorship of the estate. With a conservatorship of the person, a conservator is appointed by the court who is responsible for making decisions about the conservatee's personal matters, such as decisions regarding healthcare, food, clothing, where they live, and relationships with others. With a conservatorship of the estate, a conservator appointed by the court is responsible for handling the financial affairs of the conservatee. The conservator has the power to collect the conservatee's assets, pay bills, make investments, etc. However, the conservator must seek court permission or approval for major transactions, such as buying or selling real property, borrowing money, and gifting assets. The conservator of the person can be someone different from the conservator of the estate, or the same person can serve in both capacities. Some conservatees may have only a conservatorship of the person, or conservatorship of the person and only a conservatorship of the estate. A conservator is usually a family member or close friend. It's the responsibility of the conservator to ensure the safety and well-being of the adult who cannot care for him or herself. If there is no one willing to act as conservator, a professional such as a fiduciary or even the county public's guardian may be appointed. A general conservatorship is for adults who are unable to provide for their personal needs due to a physical injury, dementia, or other reasons that make them incapable of caring for themselves or make them subject to undue influence. A limited conservatorship is for adults who are intellectually and developmentally disabled. With this type of conservatorship, the conservator's powers are limited so that the disabled person may live as independently as possible. There is another type of conservatorship I'm not going to go and dive into much, but in case you've heard the term, known as a LPS conservatorship, it stands for Lanterman Petrus Short conservatorship, which is for severely disabled persons who, due to a mental disorder, may be a danger to themselves or others and requires hospitalization in a psychiatric facility. In our practice, a limited conservatorship of the person are the most common, which grants the conservator up to 7 powers to make all decisions regarding the conservatee's education, to have exclusive authority to give or withhold consent to medical treatment for the conservatee, to fix the residence or specific dwelling of the conservatee, to control the right of the conservatee to enter into contracts, to have access to the confidential records of the conservatee, to control the conservatee's social and sexual contacts, and to consent or withhold consent to the marriage of the conservatee. There can be an alternative to a conservatorship. You know, if the individual can understand and sign a financial power of attorney and healthcare directive, you know, the individual will retain their powers and allow someone else to act on their behalf as well, either with immediate authority or authority upon the individual's incapacity. So the difference between a power of attorney or healthcare directive and a conservatorship is that the individual retains powers, their own powers with the power of attorney and healthcare directive, while a conservatorship actually takes away their rights and powers. So now I'm going to hand it off to AJ to have us jump into a discussion about public benefits.
Excellent. Thank you, Bronson. So we'll go on to the next slide here, but kind of the next roadmap and points of discussion that we're going to have is dive into some more global issues regarding public benefits, and those that attended the presentation or webinar with Dennis McRoberts. I know he went into some extensive detail regarding SSI and those processes and the application process. We're not going to dive into that detail today. I'll highlight some issues and some changes, but I really just wanted to provide a more global context of public benefits and hopefully give you a good foundation of some of these issues and the benefits available, and to kind of see the interplay of those benefits and the estate planning and special needs planning side of things. So the first slide kind of is right off the bat. When we have a discussion with clients and we're doing some planning for clients that come to our office, we break things down into 2 types of benefits. There are entitlement benefits, which are on the left part of the screen, and then there are needs-based benefits on the right side of the screen. Entitlement benefits, as the name implies, are benefits that we are entitled to receive from the government as part of our contract of paying into the system, filing taxes, and that sort of thing. Those benefits don't have income and resource rules that we need to be aware about or concerned about. They're really just something that we can receive as a result of our contractual relationship with state and federal government. Those benefits include Social Security Disability Insurance, or SSDI. Kind of a subset of that SSDI benefit is something called a childhood disability benefit, which I'll get into a little bit more detail in a few moments, and Medicare. So those benefits we can receive, and we say in our practice, Bill Gates can receive these benefits, so we are entitled to receive these benefits. So it doesn't necessarily require a special needs trust in terms of keeping somebody eligible for SSDI or Medicare or other entitlement programs, but it's something that it's important to be aware of, and factors that we consider when we do planning for a family, when we're doing planning for a beneficiary. On the right side are the needs-based benefits, and I'll spend a bit more time this morning discussing those programs. but the needs-based benefits have pretty strict income and resource rules that we need to be aware of. And the type of planning that we do is typically revolving around individuals who are receiving one or more needs-based programs. Those programs include supplemental security income, or SSI, Medi-Cal, Medicaid, Medi-Cal in California, IHSS, in-home supportive services, CalFresh and Section 8 housing. And I'll note some changes that have happened with some of those programs as of this year. So even in the arena of the needs-based benefits programs, each program really kind of has different income and resource rules that we need to be aware of and kind of really impact the type of planning that we may need to do. Generally, when we're focusing on, or at least in part, the needs-based programs, we're really considering setting up what's called a special needs trust for that individual, because the purpose of a special needs trust, as we'll discuss a little bit later on, is to keep somebody eligible for these needs-based programs. So anything in a special needs trust doesn't count towards income and resource thresholds that these programs adhere to. And that's where we get into some specific planning tools and options for individuals who are receiving SSI, Medi-Cal, any other needs-based programs. We need to be aware what those rules are and plan accordingly. But I think just kind of right off the bat, seeing the difference between these two different programs and seeing how they fall into different categories, I think is helpful to see, because that helps paint a picture of A, what's available, what's out there for somebody, and B, the planning that goes around these benefits as well, and what we need to do to keep somebody eligible for the specific programs, the specific benefits that they're receiving. Next slide. So before we get into the specific programs, I think it's important to define how Social Security defines the term disability. The term disability or being disabled is applicable for both the SSDI program as well as the SSI program. And how Social Security defines being disabled is the inability, as noted on the slide, the inability to engage in any what's called substantial gainful activity, or SGA, due to a medically determinable physical or mental impairment, or combination of impairments, that has lasted or can be expected to last for a continuous period of at least 12 months or result in death. And in 2024, the SGA amount is now at $1,550 per month. So to kind of break that down and explain away what that language means, what Social Security is saying with their definition of being disabled is somebody can't or is unable to earn enough income each month based off of their disability. So it's not the actual disability itself that gets somebody qualified for SSI or SSDI. It's the fact that the disability that they've been diagnosed with prevents them from engaging in work and earning up, $1,550 or more a month. So I think that's an important distinction to make. It's just not, I have a disability, therefore I, get SSI or SSDI. It has to be determined that because of that disability, you're unable to work and earn enough income each month. And if that's the case, then Social Security will deem somebody disabled for the SSI and or SSDI programs. And that's really kind of the first step of getting in the door to qualify for one or potentially both of those programs. Next slide. So starting off with SSDI, so it's a federal program that really provides a monthly cash benefit to individuals with long-term disabilities that either worked or had a family member that worked and paid into the system. So for example, if I worked for 30 years, I become disabled before retirement age, I can collect SSDI until I hit that retirement age, and then I would switch over to my retirement and start collecting that. So it's designed to provide some cash benefit and supplement when somebody's no longer able to work and they haven't reached that retirement age yet. And I think probably one of the biggest components of the SSDI program is that parents who have a child with a disability, diagnosed before the age of 22, that child, when the parent retires or becomes disabled, can then start collecting, that childhood disability benefit, that SSDI payment, off of their parent's work record. And they can receive about half of what the parent receives during the parent's lifetime. And when the parent passes away, that payment will go up to about 75% of what the parent was receiving. So this is, I think, often overlooked benefit for clients and families out there, and that in many situations they didn't realize that if they have a child, often regional center clients and individuals associated with regional center qualify for this program because of their diagnosis of a developmental or intellectual disability, usually at birth or soon after, so they automatically kind of qualify for this. But if you don't do the paperwork to get it done with Social Security, sometimes that gets overlooked. That this is a really important program and benefit because it allows that child to receive essentially a lifetime annuity payment that's going to be there and supplement their care, which could be a good amount of money for the rest of their lives. And in many situations, it gets them out of the SSI world because SSDI payments are considered unearned income. And so in some situations, it does wipe out the SSI, which is a good thing. And it's nice, to get out of the SSI income and resource rules. But the childhood disability benefit is, I think, something that's really important to understand and really important to be aware of. So when parents are looking to retire and looking to transition, that they understand if their child qualifies, there is a program or payment out there that would allow their child to receive payments off their work record. It doesn't reduce the parent's payment every month. So it's not as if the parent takes a reduction in their retirement or their SSDI. They still receive what they're entitled to receive, but then the child's also going to get something off of that parent's work history as well. There's no resource or income rules, so it gets us away from some of those strict issues that we're going to come across in a few moments. And as I mentioned, the SSDI payment is considered unearned income for SSI purposes. So many situations, once the child receives SSDI, oftentimes the SSI amount will go away because SSDI is usually higher than the SSI amount that child's currently receiving. And on top of that, 2 years after the child's been receiving the SSDI payments off the parent's work history, that child, even though he or she's under the age of 65, will qualify for Medicare as well. So oftentimes Medicare becomes the primary and then Medi-Cal becomes a secondary, and sometimes parents will have a private insurance in there as well, so that that child often can have 2 or 3 insurance coverages, most of which is covered by the state and federal government. Next slide. So this is just last year's numbers, but just to kind of give you a sense of what that SSDI payment looks like for individuals who are collecting that. So I think just kind of seeing some numbers paints a picture of that's a good amount of money that somebody could receive every month for their lifetime. And if you kind of do some rough calculations for 20, 30, 40 years, that's hundreds of thousands of dollars that somebody could be entitled to receive. And that's why it's so important to make sure that when parents transition from working to going into retirement, that they inform Social Security, or at the very least make sure that their child, if they qualify, is going to switch to that SSDI program so that child can start collecting those payments for his or her lifetime. Next slide. So just really, quick note on Medicare. We get it when we turn 65, as I mentioned. The benefit of getting that child on those SSDI payments is not only will they likely receive more in monthly payments, the second benefit is that they're going to get, probably better health insurance coverage after 2 years of receiving those payments with Medicare. So it's, important to keep in mind. And sometimes, I have clients that will, one parent will start, retire somewhat early so that child can just get into that system so they can get Medicare sooner rather than later. And when both parents retire, what Social Security looks at is whoever the higher wage earner is between the parents, that's what the child will take from in terms of the SSDI payments. So if one parent retired sooner and that's the lesser wage earner, the child will start off of that parent, then switch to the other parent when that second parent retires, if that second parent was the higher wage earner between the two. So they only can take off of one parent's work history, but it would be the higher between the parents. And then there's different programs with Medicare, Part A, Part B, C with the Medicare Advantage program, and Part D. So when somebody qualifies through the SSDI program, they usually automatically get enrolled with Part A and Part B. If they're also on usually free full scope Medi-Cal, the Medi-Cal will also pick up the Part B premium as well. So that's, a cost savings there. So at the end of the day, a child can have pretty comprehensive health insurance and have a pretty good monthly annuity payment that's essentially going to give them money to use for their benefit for their lifetime. Next slide. So switching gears to the needs-based benefits program, the probably most common program out there is the supplemental security income. And I kind of think that's the gateway program to getting into the other programs and being eligible to receive other services out there as well. So the SSI, or supplemental security income benefit, gives cash for food and shelter expenses to those who are over the age of 65, blind or disabled, and really have no other income and really no other assets in their name. So it's really a poverty program that provides the bare minimum cash to get somebody a meal in their stomach and a roof over their heads, but pretty much beyond that, that's really nothing else. The federal amount that was allocated for the SSI program is $943. California has a state supplement because it's just so expensive to live here, just under $240. So somebody living in San Diego, for example, can receive up to $1182, $94 in 2024, and the SSI amount typically goes up a little bit every year with a COLA increase, and we usually know those numbers towards the end of the year. So that number has been going up. But even still, if you can imagine, many people living off of 1182 in San Diego, that's not easy to do. But many people do it, and the hope is that number continues to grow and they make some modifications to some other things that we're going to look at as well. But those are the numbers for this year, and then we'll see what next year brings. But each year that number typically goes up a little bit, hopefully more than it did this past year. Next slide. So to qualify for the SSI program is really kind of a three-pronged test. The first criteria, the first element to qualify is to satisfy that disabled requirement. And I went through that earlier on that previous slide, but again, going back to the disability diagnosis prevents somebody from being able to engage in substantial gainful activity. What does that mean? They're unable to earn more than $15.50 a month. If they meet that requirement, they meet that threshold, then they'll have that box checked off, and Social Security will then turn towards their finances and their income to see, from a financial perspective, are they going to qualify for the SSI program now that they've satisfied the disabled or disability requirement. And for the SSI program, as I'm sure many of you are aware, an individual qualifying for that program can't have more than $2,000 in countable resources in his or her name, $3,000 for a married couple. That number hasn't changed for many years, I think from the 80s. So that's very outdated, and trying to live off of $1182 a month and have less than $2,000 in your name, that's tough to do. but that's probably one of the most strict rules in all the programs out there is this SSI resource threshold of no more than $2,000 in countable resources. Granted, there are exempt resources, so the individual on SSI or qualifying for SSI can have one home, one house in their name, they're living there, that's exempt. They can have one vehicle, personal effects and belongings, those won't be counted towards that $2,000 threshold, as well as assets in a special needs trust and ABLE Act account. And there's some other exceptions as well, but generally those are kind of the main exempt resources when it comes to somebody qualifying and maintaining eligibility for SSI. So if somebody is below that $2,000 threshold, then we look to see, now that they met that financial requirement, kind of where on the spectrum are they going to fall in terms of how much they're going to receive every month under the SSI program. That's going to be based off of the income limits that we're going to be looking at here. There's 3 types of income that Social Security looks at in determining how much SSI somebody will receive. It's earned income, unearned income, and this kind of unique thing called in-kind support and maintenance. So they evaluate all income sources to determine how much somebody's going to receive in their monthly SSI amount. And depending on the month, that could change. So that could be a bit of a moving target. They could receive the full amount one month, and then that can go get chopped in half the next month. So that one is kind of always in flux in terms of how much somebody's receiving based off of other income that they're receiving that month. Next slide. So just starting with earned income. Earned income is kind of as it sounds. It's salaries, wages, tips, net income, self-employment, royalties. These are all ways that somebody can earn income, and that earned income is then going to reduce their SSI amount based off of how much they're earning, and the rule that Social Security has in place. And that rule is if somebody has earned income coming in, the first $65 is excluded, so it doesn't count. And then for every $2 earned, there's a reduction of $1 of the SSI benefit. And on top of that, there's a $20 general exclusion in addition to the rule itself. So there is some flexibility, if you want to call it, in terms of the overall reduction amount, but it's for every $2 earned, $1 in reduction in SSI, excluding $65 earned, as well as a general $20 exclusion. And I think the next slide will provide an example. So if we can go to the next slide as well. So just to kind of put some simple math here for us, if John's receiving the full amount of SSI of $1,182, he earns $585 in a month. His SSI check would be reduced by $250 and drop his SSI payment to $932 for that month. And if we can look at the calculation here, we had the $585, we take off $65 exempt, that drops us down to $520. We take off another $20 that doesn't count for that general exclusion, that takes us down to $500. We have that 2-for-1 ratio of how we come up with that number. So we divide 500 by 2, and that drops us to $250. So the $250 is the amount that's going to be reducing his SSI, and then we subtract $1,182 minus $250, and that gets us to the $932. So it's kind of some bizarre math and how they come up with that number, but that's just an example of how Social Security would take somebody's earned income and then adjust their SSI accordingly. That's the equation formula that they use, and that's how they would get to that 932 kind of in a real life situation. Next slide. So the next type of income is unearned income, and this includes gifts, inheritance, cash being directly given to the individual, dividends, any other non-earned income that somebody's receiving. SSDI is on there. So these are all examples that you can see of somebody receiving unearned income in a particular month. And the effect of somebody receiving unearned income is a direct dollar for dollar reduction in their SSI. So it's a little bit more harsh in terms of a penalty when somebody is given $500 in cash versus earning $500. that gift of $500 is going to reduce their SSI more than earning $500. And of course, we have the $20 exclusion amount on top of that. So just to be aware that unearned income penalty is a dollar for dollar reduction. So it's a little bit more of a hit to somebody's SSI check. And the next slide, I think, will provide an example of what that looks like in terms of numbers and calculations. So if we go to the next slide, going back to this example of Sally receiving the full amount, $1182. She receives a gift of $585. Now her check is going to be reduced by $565, and her total amount that she'll be eligible to receive is $617. So right off the bat, we already see that giving somebody cash directly is going to have a bigger impact on their SSI check. And the calculation is done below. We take off $20 of the exclusion amount. That drops the number to $565, and that $565 is going to be taken off the full amount. And that's how we get to that $617. And that's what Sally would be eligible to receive that month because of that $585 cash gift given to her for that particular month. So the third type of income that Social Security looks at for SSI purposes is something called in-kind support and maintenance. That type of income really means, or is defined as somebody else paying food and shelter expenses for that SSI recipient. And there's a list of what shelter expenses actually means, includes rent, mortgage, property taxes, utilities. You can see the 7 or 8 things on that list. So if somebody's paying those expenses for an SSI recipients, then we're going to be looking at taking a reduction in SSI, because Social Security is going to count that as ISM, is the abbreviation. And so we need to be mindful of that as well. In some situations, that's totally fine. So if we have many situations, an adult child receiving SSI, living with the parents, it's essentially presumed that the parents are providing food and shelter expenses. And so we have a reduction in SSI, which is fine because that child's still receiving $800 or so in SSI payments, and they're living with mom and dad. They're happy and comfortable. So in some situations, it's certainly worth taking that reduction if that provides the better quality of life for that individual. The effect of an ISM reduction is a dollar for dollar reduction up to 1/3 of that federal benefit rate, which I noted on the previous few slides ago was $934, I believe. So it's a pretty good reduction, about $300+ in reducing somebody's SSI. But in many situations, it's worth it. And I think when we're looking at taking a reduction in any SSI situation, if we have Medi-Cal connected to that as well, we just want to make sure that any income reduction doesn't wipe somebody off SSI program completely, because that's going to have ramifications for their categorically linked to Medi-Cal, and then they're going to lose that program as well. So we just need to be mindful of the incomes somebody's receiving, whether it's ISM, earned income, unearned income, the effects that's having on their SSI, and just making sure that we're not losing anything connected to that SSI program, which is going to be their Medi-Cal, because when somebody's on or receiving SSI, even just $1 of SSI, they're going to automatically qualify for Medi-Cal. And if people are using Medi-Cal as their health insurance, we don't want to interrupt that as well. So it's important that when you're doing this planning and these issues are being addressed, that you really understand the totality of the circumstances associated with reducing somebody's SSI and what that actually means for any other programs. Next slide. So a change to the ISM, or a couple of changes to the ISM rule that will be going into effect this year. So food will be removed completely from the program or from the penalty. So as of 9/30, September 30th or October 1st of this year, parents, trustees, third parties can pay for an SSI recipient's food, and that's not going to count as ISM. That's not going to result in a reduction in their SSI. So that's a a big win for, for this community. I think that's, much needed. And I think it's going to give some more, individuals more money in their pocket for other things that they may need during that, month to month, process of using their SSI funds. So that's a pretty significant change and update for SSI recipients, and that'll go into effect as of 9/30. In addition to that, the rule regarding charging fair market value for rent is also going to change. So, same date as the food being removed from ISM, we're having a change in no longer having to charge, in short, no longer having to charge a beneficiary fair market value for rent, as long as that beneficiary pays $334, the presumed maximum value of, pay that every month to whoever for rent, for parents, for example. Then that individual can receive the full amount of SSI, and there won't be a reduction in their SSI payment. So that's a pretty significant change, because actually charging somebody fair market value for rent, San Diego in particular, can pretty much wipe out somebody's SSI check. It doesn't really seem possible to do that. So this change will allow beneficiaries or recipients to receive or pay smaller amount in rent, get the full benefit of their SSI payments, and have more money for other things that they may need. And wiping out the food is also a huge thing, because it's just going to give more flexibility in providing for that individual, and having more SSI funds in that individual's pocket for other things. Next slide. So Medi-Cal, this is a program that's categorically linked to the SSI program. There's other Medi-Cal programs as well, but this is California's version of the Medicaid program. So it's a federally funded program. It's administered by each state agency. We have Medi-Cal in California, and it covers a variety of medically necessary services, including doctor's visits, surgery, emergency room visits, hospitalizations, prescription drugs, really anything that somebody needs. I know sometimes it's not necessarily the best, doctors or coverage, or not a lot of people or physicians take Medi-Cal, but it is, I think, a very beneficial supplemental health insurance program to have, in particular when somebody is receiving what's called in-home supportive services, or IHSS. So even if somebody isn't using Medi-Cal for doctor's visits and that sort of thing, they often use it for IHSS purposes. So a parent, for example, can be a caregiver and get paid under the IHSS program, under the Medi-Cal program. So that's often one of the biggest components of Medi-Cal, is taking advantage of that IHSS program as well. There's different programs under Medi-Cal, or how to qualify for them. So there's categorically linked Medi-Cal, which is connected to the SSI. Magi Medi-Cal, which is more income based and has its own separate income rules. And then there's age, blind, and disabled Medi-Cal, which is a little bit different outside the scope of the SSI program. So individuals who maybe have to pay a share of cost, they would qualify and apply for that type of Medi-Cal program. When somebody applies, Medi-Cal typically does their best to get them on the best Medi-Cal program available, but there are different programs that people can apply for, and just depending on the financial situation, they'll fit into whatever program best suits their needs. Next slide. And another change for Medi-Cal as of January 1st of this year, Medi-Cal's eliminated the resource limit. So Medi-Cal historically was connected to the $2,000 resource limit of the SSI program. That was bumped up to $130. That was for like a year and a half or 2 years. Now Medi-Cal, as of this year, has no resource threshold. So somebody can have, $300,000 in their name, and they can still qualify and remain eligible for Medi-Cal. So this is only for Medi-Cal only recipients. So if somebody's on SSI and Medi-Cal, they still have to adhere to the $2,000 resource threshold. But if somebody's receiving SSDI and Medi-Cal and Medicare, and we're only focused on Medi-Cal, that because of the change in rules, we have some more flexibility in what we can do for planning purposes. Medi-Cal still looks at somebody's income. So even though somebody can have a chunk of assets in their name, Medi-Cal is still going to review income from all assets associated with that individual. And if their income is above, I think right now it's 1732 a month. If they're above that amount, then they're going to be assigned a share of cost. If they're below that amount, they'll still qualify for free full scope Medi-Cal, and they can still have a chunk of assets in their name. So that's a pretty dramatic change in Medi-Cal's procedures and analysis of applications and eligibility requirements. And I think that's given us some more flexibility in what we can do in planning purposes. So even if somebody's only on Medi-Cal and they can have a sizable amount of assets in their name, I think there's also a practical component and considerations as well, because we want to ensure that there's no issues of undue influence or somebody gifting funds away. So even if we're only focused on Medi-Cal, I think we need to think too about what does that look like if somebody had that money, all that money in their name at once. Is that a good idea? Is it best to set something up for them, even though we're only focused on Medi-Cal? So I think there's things that we need to think about beyond the legal context, so we can plan accordingly and preserve assets for somebody, and we can avoid and mitigate issues of undue influence and that sort of thing.
Do we have time for a couple of questions? AJ?
Sure.
Okay. So the first one is, will this presentation be shared with the participants? If you're talking about the PowerPoint, that is the plan. AJ and Bronson can get me the PowerPoint afterwards. And if you're interested in receiving it, I can email it to you. Just email me. It will also be on our website once we convert the video under virtual seminars to answer that question. And then the second question, AJ, can you see these questions here? My adult child? It's to the right. You may not be able to see it. My adult child has some abilities, but feel he'll need certain general and financial functioning supports. In trust, is there a way to modify a special needs trust or arrange a regular trust to accommodate his future alone?
So setting up a special needs trust, I think with like estate planning options, those types of trusts are designed to be flexible and giving trustee discretion on adapting to somebody's life situation. So if there's changes that are going on, the administration of that trust can be adjusted accordingly. If legally something had to be fixed to accommodate an issue, you can always modify that, whether it's within your own private structure with an attorney, or if necessary to go to court.
Okay, and then question number 2 is, can you keep Medi-Cal if you are above the income limit if you pay share of costs?
Yeah. I mean, you're just paying a share of cost. So I mean, you can have a share of cost and have Medi-Cal. I mean, at some point, if the share of cost is so high, it doesn't necessarily make sense to do that. But if you're close to that monthly amount, there's ways to bring the income down below that threshold.
Okay. And I think we have one more question that we can go on here. For our adult disabled child who gets SSDI, does the parent need to be receiving SSA to be considered retired, or is retired when the parent is over 65 and is not working?
So the child can collect once the parent starts collecting their retirements, or the parent becomes injured and is collecting SSDI themselves, then the child can start collecting. And that's just notifying the Social Security office about that. And the benefit of getting somebody on SSI before the age 22 is that that information would already be in the system. So it makes that process and that transition smoother, instead of, parents wait and they don't get on, the SSI program until after 22. It gets a little bit more challenging. But in many situations, you get on SSI when they're 18 or 19. They have that diagnosis in their system, so it helps that process and getting switched over.
Okay, one more question and then we'll wait for the other ones till later. If the disabled person has private insurance, is Medi-Cal considered primary and private considered secondary?
So that just depends on what the provider is going to take. So, I mean, if you have typically the private is a primary, Medi-Cal is a secondary, but you can present both cards, both information when you go to appointments, and see what the doctor's office will take, what they'll pick up. So it just kind of depends.
Great, thanks.
Sure. So one last, we go to the next slide. One last thing I want to comment on for Medi-Cal is with the change in Medi-Cal rules and resource thresholds, there's been some changes, some recent changes in terms of setting up a trust for somebody who's only on Medi-Cal. And I think this is becoming probably a little bit more of a relevant discussion now because of that resource elimination for Medi-Cal individuals. So now if somebody's on Medi-Cal, what they can do to remain eligible, if they have $500,000 in their name, is have those assets placed into a revocable living trust, and assets in that revocable living trust or income generated from those assets won't count as income for Medi-Cal purposes. And if distributions are made directly to third parties and cash isn't given directly to the beneficiary, none of that's going to count as income. So somebody who can be on Medi-Cal can have sizable revocable living trust, income generated and retained in trust doesn't count. If distributions are made appropriately, those distributions won't count as income. But if you take that very same $500,000, put it outside of a revocable living trust, all of that will count. So the very fact that you can actually set a trust up for somebody and keep them eligible for Medi-Cal and avoid probate issues and avoid Medi-Cal state recovery issues has kind of paved a new path for some of the planning that we're doing for beneficiaries when they come across assets directly in their name, or they have assets directly in their name. So that's a bit more of a nuanced issue that's developed as a result of some of these changes. Just to kind of put that out there, we have some flexibility for some of these planning options for Medi-Cal only recipients. And next slide. And some other benefits in-home supportive services at IHSS. So this program, I think, is very common and very popular under the Medi-Cal program, and essentially allows somebody with a disability to stay in their home instead of being institutionalized. And I think the theory behind this is that it's cheaper to pay somebody to take care of somebody at home rather than having them placed in a facility. So for the IHSS program, it's what somebody actually needs physical assistance with versus reminding somebody to do something. So a parent or somebody else gets minutes or hours and time allocated and paid for if they demonstrate that this individual physically needs assistance with washing their hair, using the toilet, getting dressed, that sort of thing. Reminding somebody to brush their teeth won't get you any minutes or hours or time. It's the actual having to do something for somebody because they can't do it and they need that help to remain safely in their home. So that's, I think, a really important program. And I know many clients and families we work with, use that program and take advantage of that program. CalFresh is, somebody on SSI can receive CalFresh, and that's just additional money that they can receive every month for food expenses. And then lastly, Section 8. It's a housing program. I think it's important to note the changes that are coming or have developed for that program. There's a voucher program and a project program and a home ownership program. This time, for this presentation, we don't have the time to get into all of that, but I do want to comment is on the next slide for Section 8, really quick before we get into special needs trusts. So we can go to the next slide. As of this year, Section 8 had some updates in their rules. They do now have $1,000 resource threshold. They didn't have a resource threshold before. They do now, and we need to be aware of that when we're doing planning. And there's been changes to other requirements, including self-certification and reporting requirements, and reporting net family assets every 3 years, changes to their analysis and view of income rules. And importantly, what's changed is that under their updated rules, distributions of principal from an irrevocable trust, including a special needs trust, won't count as income for Section 8. So that's been a huge change. There are other exemptions, I believe, that would allow somebody to get distributions from a trust if necessary. But we have legal authority now that's a law, just not a case law, but actual law that allows distributions of principal to be made, and that won't count as income for a Section 8 beneficiary or recipient. So I think that's emphasized in many situations the need of having irrevocable, at very least, a first or third party S&T in place to keep somebody eligible for this program. So just wanted to put that out there. And with that, I'm going to switch gears to special needs trusts and dive into these instruments, and we'll get us going here. So the previous slides went into a lot of discussion on the benefits, what's available, what's out there for somebody to receive, and now we're going to discuss instruments to keep somebody eligible for those programs, and flush out some details in that regard. So, right off the bat, what is a special needs trust? I think that's a good starting point for this discussion. It's an instrument or a document that defines how assets in that trust will be used and who they will be used for. And the beneficiary is the person that gets the benefit of having that trust in place. A special needs trust, in particular, first party special needs trust, is very specific and unique language that needs to be in it, so it doesn't count as a resource for SSI and Medi-Cal purposes. And part of that structure and the language in that trust is to remove any type of control that a beneficiary has over those assets, because the beneficiary can't have control or even the appearance of control over assets in a special needs trust. Otherwise, it's going to count as a resource, and that's going to be problematic. So we have to draft it in a way to remove control from the beneficiary and grant that to the trustee. Now, if it's a special needs trust, whether first or third party, can have bank accounts, investment accounts, and real property held in it, so it can hold a variety of assets in trust. The trustee is in charge of the assets, having complete discretion over managing and making distributions for the beneficiary. And so that's in a very brief nutshell what a special needs trust is, going back to this idea of creating an exempt mechanism that allows somebody to receive assets and remain eligible for any needs-based benefits programs that they may be receiving. Next slide. So there's two types of special needs trusts, and the way we figure out what type we need to create, what type we need to establish, is looking at the source of funding. So if the beneficiary has control over the assets and is funding the assets with his or own, funding the trust with his or own assets, then we're creating what's called a first party special needs trust. If somebody else is funding the trust with their own assets, then we're looking at setting up what's called a third party special needs trust. So this is the threshold issue of what direction we're going to go in, and there's consequences for doing the wrong thing. So we need to make sure we have this issue fleshed out initially, so we know what type of trust we need to create, because as we're going to see, there's some pretty significant differences between a first party and a third party special needs trust. So we need to understand this aspect of everything before we dive into the type of trust we need to create. So going back to it again, the beneficiary owns assets and is putting assets into that trust, we have to create a first party trust. And if anybody else is setting up and funding a trust, then it's going to be a third party trust. Next slide. So just some characteristics of a first party special needs trust. These types of trusts go by a variety of names, as you can see on the slide: self-settled litigation SMT, payback trust, over 93, D4A. So if you're researching these trusts or discussing them with somebody, if somebody's using a different name, they all refer to the same type of trust. A first party trust or first party SMT can be established by the parent, the grandparent, the legal guardian, the court in some situations, or the beneficiary. And the beneficiary having the ability to do that was somewhat new, but having that as an option has been very beneficial, because now that individual, they're over 18, they're competent, but they need to set up a trust, can do it themselves. They don't have to rely on somebody else. They don't have to go to court to do it. So that was somewhat new, but it's been a nice change in having that as an option. Kind of goes without saying, but the beneficiary, in order to set this up, has to have a disability, and that's almost always met because we're working with somebody on SSI and Medi-Cal, so they've been diagnosed with a disability. But that's just something to emphasize and reiterate. The beneficiary, to set up a standalone trust like a D4A trust, standalone instrument, has to be under the age of 65. A pooled trust option, which we'll discuss in a little bit, is available for individuals who are over the age of 65. That's really their only option. But if somebody's over the age of 65, we have to look at a pooled trust. If they're under the age of 65, then they can set up a standalone trust or even a pooled trust if appropriate, and they wanted to do that. As I mentioned earlier, we can't have the beneficiary have any control over trust assets. The trustee has sole and absolute discretion over these funds. That's necessary to make it a valid SNT. So the beneficiary can't compel the trustee to make a distribution. Trustee or the beneficiary can't remove a trustee. Beneficiary has zero control of the assets, but in turn, distributions can only be used for the sole benefit of that beneficiary. So the beneficiary doesn't have control, but the trustee, whether that's an individual, pool trust, what have you, can only use the funds to benefit that individual. With that being said, there's little exceptions to that rule, of course, and I like to provide the TV example. If a trustee bought the beneficiary a new TV for his apartment, it doesn't mean somebody can't watch a movie with the beneficiary or watch something on their own with that TV. So there is that kind of derivative benefit that wouldn't violate the sole benefit rule. But barring some kind of minor exception like that, funds can really only benefit the beneficiary, and really no other third party can benefit from a distribution from a first party trust. Next slide. If a beneficiary is a minor or doesn't have capacity and they're over age 18, then we're going to court to petition the probate court to establish a first party trust. We can avoid that. We like to, but in some situations, that's our only option, and that's a bit more time consuming and expensive in terms of getting that set up. But in those situations, that's our only option, our only recourse, and so that's what we have to do, and that's subject to potential court accountings. So that can get pretty expensive, but is often the only option in those situations. The trust is irrevocable, so in terms, everything's locked into place once it's created and established and funded. But we do have the trustee or grant the authority to the trustee or somebody else to amend the trust if necessary. Rules change in the public benefits arena. If we need to make a modification to a trust to keep it valid, we want the trustee or somebody else to have the authority to amend it so it's compliant with updated rules and regulations for Social Security, for Medi-Cal. The biggest component of the first party trust is the Medi-Cal payback provision. This is a mandatory provision in all first party trusts, and it states that when the trust terminates, when the beneficiary passes away, or during the beneficiary's lifetime, Medi-Cal is entitled to get paid back for all of the services they provided the beneficiary for his or her lifetime. So this is a lifetime Medi-Cal lien on trust assets. It's not a lien from when the trust is created. It's, for however long the beneficiary was receiving Medi-Cal. It is a lifetime lien, and sometimes it can be pretty significant. It can be pretty high, but Medi-Cal can only claw back up to the current balance of the trust. So if there's a lien that's $200,000 and there's only $10,000 left in the trust, Medi-Cal can only get the $10,000 and that's it. They can't go after the trustee or anybody else for additional funds. They are limited to what's in the trust itself. And the lien language has very specific, or lien provision has very specific language. So when these trusts are put together and drafted, we need to make sure they're done correctly, because Social Security and Medi-Cal review these instruments to make sure they're valid. And if there's an issue in particular with the lien payback language, then we could run into some issues, and that's something that we want to avoid. Next slide. So just some examples of how a first-party trust can get funded. A couple of common scenarios are personal injury and medical malpractice settlements. So we work with PI attorneys, plaintiffs attorneys to get these trusts created and funded with those proceeds. Direct inheritance or gift. So if somebody's named directly in a trust or on a beneficiary designation form, they have ownership interest in those funds, and then we need to set up a first-party trust for those for those assets. Retroactive SSDI payments, I think that's a little bit less of an issue because of the change in Medi-Cal rules. Usually, if somebody's on SSDI, they're only on Medi-Cal, they're not getting SSI anymore. So that source of funding might change just based off of circumstances. If somebody's getting SSI and SSDI, still may be relevant to set up a first-party trust with retroactive back payments. And then being direct beneficiary on any beneficiary designation form, being an owner or a beneficiary of custodial accounts, when those vest when that individual turns 18 or 25. These are all examples of how somebody comes across assets and own assets, which then requires a first-party special needs trust to be created. Next slide. A few other examples. So CalSTRS. So if clients are paid into the CalSTRS program as teachers, they can name a first-party trust as a beneficiary for those retirement payments. Sometimes we work with clients who are in the military and they signed up for the survivor benefits plan. We can set up a first-party trust and some additional documents to have those payments pay into that first-party trust. And then court-ordered child support payments. We work sometimes with family law attorneys to ensure the right language is in that MSA, to ensure child support payments will pay into a first-party trust, so we don't have any income issues or resource issues for any of these payments at some point in the future. And I'm going to skip just the common mistakes just for time purposes here, and I'm going to turn things over back to Bronson.
All right, so let's talk about third-party special needs trust. A third-party special needs trust is commonly created by parents or grandparents in conjunction with their own estate plan and trust. And there are some, notable differences when compared to a first-party special needs trust. One, third-party special needs trusts do not need to be court supervised, regardless of the beneficiary's capacity. There is no sole benefit requirement for third-party special needs trusts. And with third-party special needs trust, the trust is funded with gifts from third parties. So again, assets that belong to anyone other than the beneficiary. And because the assets in third-party special needs trust do not belong to the beneficiary, the trust assets are protected from the beneficiary's creditors and other third parties. And perhaps most notably, that there is no Medi-Cal reimbursement requirement like there is with first-party special needs trusts. So since third-party special needs trusts are funded with assets that belong to someone other than the beneficiary, they're typically funded with an inheritance from the beneficiary's parents or perhaps other family members, where the special needs trust is named as a beneficiary in a trust, or perhaps a payable on death designation from an investment or retirement account, or a life insurance policy typically held on the life of a parent or grandparent. Or sometimes the special needs trust is funded from lifetime gifts from other family members or friends. So at our firm, we almost always prepare third-party special needs trust as a standalone trust document rather than as a testamentary sub-trust. And there are numerous advantages for doing it this way. For one, you maintain a greater level of privacy for the settlors, particularly as it pertains to their own revocable living trust. Anyone entitled to see the third-party special needs trust, such as like a public benefit agency when reporting the trust, won't see the settler's revocable living trust. And if the beneficiary is later determined to be able to handle his or her own financial affairs, the special needs trust can be terminated without affecting another trust. As a standalone document, the special needs trust can have different terms from the parents' trust, such as different trustees or remainder beneficiaries. Having a standalone special needs trust makes it easier to title assets in the name of the special needs trust or to designate the special needs trust as a beneficiary of again, life insurance policies, retirement plans, or and any other, accounts or assets with beneficiary designations. If the beneficiary's parents get divorced, a standalone special needs trust won't be affected if the parents' joint revocable living trust is terminated. And they can still direct gifts to this third-party special needs trust in their own respective estate plans. So common mistakes with third-party special needs trust. First of which is just simply not knowing about third-party special needs trusts, particularly when the parents believe that they have to disinherit their child in order to preserve the child's public benefits. Disinheritance leaves the child at the mercy of the government policy, which, with no guarantee that the government will continue to make public benefits available to the child. And disinheritance provides no plan for continued advocacy or care for the child. Another common mistake is funding a third-party special needs trust with the beneficiary's own assets. In regards to drafting errors, a third-party special needs trust should not include Medi-Cal payback language. A third-party special needs trust should not allow the beneficiary to demand or direct distributions from the trustee or have the power to amend or revoke the trust. A third-party special needs trust does not need to be irrevocable to preserve public benefits. As long as the trust is not revocable by the public benefits recipient, the trust assets will not be considered countable resources for SSI and Medi-Cal eligibility. A revocable third-party special needs trust gives the settlor the flexibility to modify the trust if the beneficiary's circumstances change. Having certain termination provisions is also prudent. Generally, the third-party special needs trust will terminate on the death of the beneficiary, but the third-party special needs trust may also terminate if the beneficiary, becomes ineligible or no longer dependent on public benefits, or if the size of the trust estate is so small that it's not really economical to continue to administer. But perhaps the most common mistake we see with third-party special needs trust is an overly restrictive distribution standard, which would be language in the trust that says that under no circumstances can a trustee make distributions for things that would otherwise be covered by public benefits or cannot diminish public benefits in any way. Whereas a fully discretionary distribution standard is more advantageous in most circumstances, which allows the trustee to have sole and absolute discretion to make distributions for things that may otherwise be covered for by public benefits if the trustee determines that any loss in benefits is outweighed by the increased quality of life or is in the overall best interest for the beneficiary. A common example would be, to purchase or maintain a residence for the beneficiary. And if the beneficiary is receiving SSI, such distributions would be counted as in-kind support and maintenance and reduce the SSI benefits. But, such a reduction in SSI may be outweighed by the increase in quality of life that the residence might provide to the beneficiary. Administrating special needs trust is pretty complex oftentimes. So the trustee can be a corporate trustee or a private professional fiduciary. And in such situations, the special needs trust should give someone other than the beneficiary oversight over the administration, and particularly the power to remove and replace trustees. Generally this is handled by what we call a trust protector or a trust advisory committee. The role of the trust protector or advisory committee is defined by the terms of the special needs trust, but the usual role is to provide guidance to the trustee regarding the beneficiary's needs, to help resolve disagreements or dissatisfaction with the trustee, and when needed, to remove or replace a poorly performing trustee. The trust protector is often someone who is acquainted with the settler's family and understands the needs of the beneficiary. The trust protector is typically authorized to review accountings and oversee how the trust assets are being invested. They can authorize modifications to the trust to keep it current with changes in laws or circumstances in the beneficiary's life, or even to simply correct errors or ambiguities in the trust. But overall, just to ensure that the trust is being administered as the settlers intended. A trust advisory committee is essentially just multiple trust protectors acting together, and typically includes family members, friends of the beneficiary, and sometimes professionals. Family members and friends can assist the trustee in understanding the day-to-day needs of the beneficiary, and sometimes just to provide a voice for the beneficiary to help bridge any communication gap. Professional members of an advisory committee may include, clinical social workers who can provide care management for the beneficiary, consultants, such as like an attorney who is familiar with Social Security and Medi-Cal regulations to ensure that distributions don't violate any income or resource rules, or financial professionals who can design an investment strategy for the trust assets. A letter of intent, sometimes referred to as a memo of intent, is essentially an informal document prepared by the settlors, typically the parents, which can include just about anything, but the general purpose is to provide useful information to the trustee and future caregivers, such as what makes the beneficiary happy, what makes them sad, what foods do they like, dislike, what are the beneficiary's hobbies. The beneficiary might be involved in day programs or sports, or maybe they have a caregiver that accompanies them to extracurricular activities. It's good to include information about the beneficiary's doctors, medications, any allergies they might have. Parents sometimes include, what their hopes and plans are for the child's housing in the future. Would the beneficiary do well in a group home, or benefit more by being in their own apartment or by staying in the family residence? The letter of intent, should include services and public benefits that the beneficiary currently receives or is anticipated to receive. Are they receiving SSI or SSDI, Medi-Cal or Medicare, low-income housing benefits or food stamps? To be most effective, the letter of intent should be, continually updated over time. It doesn't have to be notarized, but it should include the date when it was prepared or updated so that the successor trustee will know, what's the most recent version. So actually with that, I'm just going to give it back to AJ to start us talking about pool trusts.
All right. So as I mentioned before, we have a pool trust, special needs trust as an additional option when it comes to, planning purposes. And so for individuals over the age of 65, getting funds directly, a pool trust is really their only option to maintain eligibility for their public benefits. But I think it also serves as a great option in general when we are, doing special needs planning. And when I have discussions with, attorneys and other professionals, they're often not aware that this is even something to consider. And when I kind of explain how it works and fees and everything and the economical aspect of it, it really, turns a light bulb on, and they think that, it's a really good idea. So I think it's something that, maybe people out there aren't necessarily aware of as an option when we are doing, whether it's first or third party planning, to consider a pooled trust as an option. So a pooled special needs trust is a nonprofit organization, like the Foundation San Diego, and they serve as the trustee of what's really a master trust, master special needs trust agreement. So there's really one trust agreement that's applicable to all beneficiaries versus creating a standalone trust for 10 different beneficiaries, the same 10 beneficiaries joined a pool trust, they would all follow the same master trust agreements. And participants or beneficiaries, when they decide to pursue a pool trust, they join the master trust agreements via some documents that have to get submitted and signed off on, but there's no need to write an individual trust for that individual. It's really getting documents and things that are necessary to actually join that master trust agreement, and then the pool trust organization usually serves and almost always serves as the trustee of that master trust, and then the individual or whoever is working with certain individuals at that pool trust company organization in terms of distribution, that sort of thing.
I'm not sure if it's working or not.
I'll take it right now.
Pool trust option certainly can be more cost effective, and I think it really is, many situations, in particular for smaller amounts of funds, a very cost effective approach for special needs planning. And I would say Foundation San Diego probably has the lowest fees in terms of trustee fees and advisory fees, probably within the California. So their fees are very, very reasonable for the services they provide. But a pool trust in general is typically a pretty cost-effective approach because trustee fees and other fees are typically lower than somebody else, fiduciary or a corporate trustee, bank, that sort of thing getting involved. And a pool trust, depending on the organization, the company can have either a first or third party trust available. Some just do first, some have both. So it just depends on the company and who you're looking to connect with. Next slide. So advantages of using a pool trust. The trust already is in existence, right? So we don't have to spend time creating the trust and getting that into place. That's all ready to go. So we don't, there's time saved in having to get that done and drafted and prepared and signed off on. We don't have to worry about doing that. And as I mentioned, it's usually less expensive to administer than a fiduciary or corporate trustee. You're charging hourly rates or percentages in terms of fees. Don't get me wrong; those individuals do a great job and or should be used in many situations. But just focusing on pool trusts and comparing those aspects of things, typically pool trusts can be less expensive. Assets are pooled together, hence the name of a pooled trust for investment purposes. So I like to describe when somebody is considering joining a pooled trust, it's kind of like joining a bank, right? You have one master contract, master trust agreement that everybody signs up for essentially and is connected to, but then in turn, everyone has their own sub account, their own bank account, while assets are being pooled and for investment purposes for good returns and keeping fees down. But each individual beneficiary that pool trust company. Trust really provides some stability for ongoing trust administration. These companies, organizations, have been around for many years and will continue to be around for many years. So I think there's a sense of security and stability when I'm working with a pool trust. They're going to be there. They're not going to retire or no longer take S&T work, that sort of thing. So I think there's some peace of mind and assurance that if you're connected with the pool trust, you're going to have that stability in the near future and in the long term as well. And when you work with a pool trust company, you're removing, I think, a lot of the responsibilities and duties to delegating those duties to somebody else, a professional organization, passing that
I can get whoever this is to mute. I can't mute them. Bronson, since you're host, can you ask them to mute? I can't do it because I'm not host.
Yeah, I'm not exactly sure where the noise is coming from, but if everyone would be so kind as to just mute their mics for now, that would be much appreciated.
Okay. All right. Maybe it'll stop. Let's go. Go ahead.
So when you work with a pooled trust company, you're kind of taking the responsibility away from family and friends, and you're not putting them in charge of the money. You're giving that to a professional organization to handle and maintain. So I think there's value and benefit there as well, where the family can still just be family and assist and advise and advocate accordingly, but it's not putting somebody in charge of somebody else's assets, and then you're kind of dealing with those tricky situations and concerns sometimes that come up in that situation. And a pooled trust, they're trustees as an organization that have knowledge and expertise with special needs trust and public benefits planning. The foundation, for example, they as an organization they have that knowledge, and then you work directly with Meredith, for example, as a fiduciary who has that knowledge and background and expertise as well. So you kind of get that dual benefit of not only you work with an organization, but you then work with somebody a licensed fiduciary who has that background and expertise to work with families on making distributions of that sort of thing. So I think there's certainly value in that as well. Next slide. So the typical process of establishing and opening up a pooled S&T is completing the necessary paperwork, which is typically called a joinder agreement. So it's the information that you submit to join the organization. Sometimes there's some additional information that's necessary for opening the account and consulting with the attorney and getting other documentation submitted. So there's other requirements that may have to go into effect, in particular if we're doing a court establishment of a pooled trust and that sort of thing. But typically the process is to get all the information, the joinder agreement, other documentation prepared, public benefits information, identification, other things all submitted to that organization, any other kind of specific requirements they have. And then it's typically reviewed and approved. And then once that's taken care of and signed off on, everyone signs off on the documents, it's just a matter of getting things established and funded and coordinating next steps in terms of spending plan and coming up with ways to use the funds to benefit that individual. I'll have Meredith comment on fees and more specifics with the foundation. The next slide, if we can go to that, I think just outlines the processes, and more specifically with the foundation for first party and third party trusts. So the foundation itself does first party S&Ts and third party S&Ts. So depending on the situation, the process I think is pretty similar. I think there's some differences in particular with first party trusts that we have to get approved through the court. But generally the process is getting the beneficiary. When I get these things established and sent over to Meredith, I go through the documents with the beneficiary and or the family. We review the joinder agreement packet, the joinder agreement itself, the trust, answer any questions about that, discuss the mechanics of how everything works. We go through it's called a limitations disclosure statement of highlighting I think the pertinent aspects of joining the foundation and elements of the trust and that sort of thing. So we can go through all that together and discuss everything. I work on completing the joinder agreement on behalf of the beneficiary of the individual. And so we go through all that process, meetings and just confirm everything. I get everything submitted and approved. And the foundation in particular is good at getting everything back and approved pretty quickly, so we can move on getting things funded soon after. In particular, with the first party trusts, if we're dealing with settlement proceeds and that sort of thing, it's good to get that done as soon as possible, or even inheritance waiting for distribution. So the timing on that can be pretty fast, and getting that done quickly with the foundation is to the advantage of the beneficiary, so we can get things established and funded as soon as possible. Third-party trusts, I think, are a little bit different because those are connected with estate planning structures and revocable living trusts, and that requires the parents completing similar paperwork, a little bit different. But I think that the biggest difference there is making sure that anything that's allocated to a third-party trust, with the foundation, for example, is specifically addressed in the appropriate testamentary document, almost always a revocable living trust, so that anything allocated for little Billy is going to go to the foundation's third party trust and the right language is in there. that needs to get reviewed, usually the pertinent provisions of the trust reviewed by the foundation just to make sure it's correct. So that's a little bit different in terms of third-party trust planning versus first-party trust planning. And typically a third-party trust planning, that usually doesn't happen until the parent or parents pass away, and then funds from the revocable living trust pay into that third-party trust. So that the process and timing of funding is a little bit different between the first party and the third party. And the beneficiary can be anywhere in California. So for third party and first party planning, if you're thinking about going with the pooled trust, the foundation is certainly a good option for anybody within the state of California. And with that, I will turn things over to Meredith so she can discuss some more specifics about the foundation, and we'll go from there.
Yep, I will do that. But first, we have some really good questions that ties into what you were just talking about. Can a pooled trust be named successor trustee of an existing trust, special needs trust?
So they can't be named a successor trustee because they are different trusts. So it's really a trust transfer. So if there's language that you can include in an existing SNT authorizing the trustee to transfer it to a pooled trust, but the foundation, for example, it won't serve as a trustee of an existing SNT. They're the trustee of their master trust agreements. So it really would be a transfer, not a successor trustee component.
Okay. And one more question. If my disabled daughter has a conventional trust, third party, run by a bank and appointed lawyer, does she need a special needs trust for SSDI and Medi-Cal? It will be given to charity upon her death. Does she get monthly distribution, she does get monthly distribution, but her monthly taxable income is below the limit for Medi-Cal. We are in the process to sign up for SSDI based on my retirement benefits. Do you want me to, that's a lot. Do you want me to just start with the first part?
Yeah. Well, I think a component of that's going to be based off of what the trust says. So that's a little bit more complicated, just because there's probably language in the trust regarding distributions and planning and that sort of thing. So it'd be hard to comment on if there's issues with that. Typically, what I'll say is that even if somebody's only on Medi-Cal as a needs-based benefit program, having a third-party trust in place there's no harm. I think that it's still a good idea to have a properly drafted third-party special needs trust as a standalone document in place, because it's going to be exempt for Medi-Cal purposes. It's going to be protected from creditors and other third parties and that sort of thing. So there's still a lot of benefit of having it structured that way. The trust in place without reviewing it and analyzing the terms and that sort of thing, I couldn't necessarily opine if there's issues or what the next best steps would be.
Okay. So Bronson, I'm going to take back control here so I can share my screen. Okay. All right. I just wanted to direct you all to our website. Here's the URL, okay, the sntf-st.org. And everything that Bronson and AJ discussed about pooled trust, the master trust, the joinder agreement can all be found on our website. There's a lot of really good information on here, how the trust works, what the trust can pay for, and what it can't pay for, and that sort of thing. If you mouse over Join the Trust under Forms and Docs, you'll find the first party master trust 2, and then the joinder agreement that corresponds to that, and the limitations disclosure, our investment policy. In the joinder agreement, it will review the fees, and I'll go over that too. But really you can see what the main master trust is. For the third party master trust, we have it right here, as well as the joinder agreement. the limitations disclosure. In the joinder agreement is the information sheet, which is Bronson discussed, which is important because it tells about your child and gives information there. So this really has a lot of good information. On the about page here, it talks about, which we talked about the last seminar, so I won't go over it too much, but how the Special Needs Trust Foundation was formed and the board member agencies who sit on our board. So, you know, they're all nonprofit agencies. Having said that, with the first party special needs trust or the self-settled trust, there's $1,000 joinder enrollment fee once the beneficiary joins the trust. And once the trust is funded, we simply take that from the account. Any trust between $10,000 and $120,000 is a flat $100 per month fee billed quarterly. So basically $300 billed quarterly, $1,200 a year. If it falls below the $10,000, then there are basically no fees if the Special Needs Trust Foundation has over 3 transactions for that account. So if that trust, if we write 3 separate checks or ACHs or whatever it might be per month, then it's $25 per transaction over the 3. Other than that, there are no fees until the trust is spent down. Anything over $120,000 is 1% per year billed quarterly, but it's 1% annually billed quarterly. Okay. There are some investment fees. Our investment advisor is Morgan Stanley, and they're 0.67% annually. So they're very, very low. If anybody's familiar with investments, I mean, that's really as low as you can get. But that's the whole benefit of having a pooled trust, is our investment fees are very low. For a third party special needs trust, as AJ and Bronson discussed, that's all that, you know, you as parents would set up for your child. And we basically just keep the joinder agreement and all the information here until the trust is funded. You can fund it during your lifetime, and some parents do, and some just wait until they're no longer around, and then the trust funds. There's $100 joinder enrollment fee with a third party special needs trust. And the only fees are if there are over 3 transactions per month, there's a $25 fee per transaction. Okay. And both of these trusts, as AJ and Bronson discussed, can be spent down. In a first party special needs trust, if the beneficiary passes away before the trust is spent down, then Medi-Cal will make a claim. And 99% of the time, the money goes back to Medi-Cal. In a third party special needs trust, you can name the remainder beneficiaries. At least 25% must go to the Special Needs Trust Foundation, and at least 25% must go to a board member agency. And you see that here. So you can select who you want to go to. Now, the remainder, you can have remaining beneficiaries that cannot be the donor, cannot be, obviously wouldn't be the beneficiary. I mean, they would have been passed away, but you can't name them. It has to be somebody totally different. And you can have 2 or 3 remainder beneficiaries under the Special Needs Trust Foundation and the board member agency. That is really all about us. If you have any more questions about anything related to us, you can always contact us. I have our contact information here. This is our main website, main email, sorry, and our office number. The website really does give you a lot of good information on how it works. And AJ and Bronson are also available for, estate planning, legal questions, and how to set everything up. Does anybody have any questions? And AJ and Bronson, have you concluded your presentation? Do I need to make you host again so you can share your screen?
Yeah, if you would give the share,
Okay.
give me back to me so we can kind of finish up with just
Yeah.
Able accounts and TrueLink cards.
Okay, I will do it. Let's see. Try to figure out how to do it. No, just kidding. Let's see here. Here we go. Here we go. Okay.
Okay. So I'm going to talk to you about Able Act accounts. So the Achieving a Better Life Experience Act is a federal law that was enacted in 2014. And it provides individuals with disabilities a special type of investment account that allows them to save significantly more than the $2,000 that they've been limited to under programs like SSI without jeopardizing their benefits, while also providing, some level of independence and control over their own funds. To be an eligible individual, you must have a disability that occurred before your 26th birthday. There are two ways to show this. One, if you receive SSI or SSDI benefits, you are automatically eligible to open an Able Act account. If you do not receive SSI or SSDI, but still meet the age of onset requirement, you can still be eligible if you self-certify, which means that the beneficiary or his or her legal representative attests under the penalty of perjury that the beneficiary has a qualifying disability that occurred before the age of 26 and has obtained a letter of certification from a licensed physician stating that the beneficiary meets the Social Security's criteria regarding significant functional limitations, which is essentially a disability that, as AJ described earlier, can be expected to result in death or has lasted or can be expected to last for a continuous period of 12 months. Or if you're blind or have a condition on the Social Security's list of compassionate allowances. You don't need to provide the doctor's certification when you apply online. You just need to hold on to it. One day the IRS or the Social Security Administration may ask to see it when they learn that you have an Able Act account. So currently, the law requires that the individual's disability must have occurred before the age of 26. But in 2022, fortunately, a new law was passed that increased the age of disability to 46. But the change doesn't go into effect until January 1st, 2026. So where are Able accounts available? There are Able programs available in roughly 39 states now. An eligible individual can use any state's program, and for most programs, you don't have to reside in that state. In California's Able program is called CalAble. California residents with a CalAble account are protected from Medi-Cal estate recovery claims. Medi-Cal is prohibited from filing a claim to recover any payments for services after a beneficiary has died, which gives the beneficiaries an opportunity to leave something for their loved ones. However, CalAble accounts currently do not allow the designation of a payable on death beneficiary. So anything remaining in the Able Act account when the individual passes away will go to the individual's estate. And as I kind of mentioned earlier in the presentation, if the total value of the individual's estate is less than the probate threshold amount of $184,500, which increases every few years, the successors in interest, which will be the individual's heirs at law or the closest living relatives, can again submit that small estate affidavit to collect what remains in the account. If the individual's estate is greater than the probate threshold amount, then as we talked about earlier, full probate will likely be needed. Who manages the Able Act account? The beneficiary is the owner of the account, and if they have capacity, they can manage their own distributions. This is, the direct opposite of a special needs trust, which is administered by the trustee, and the beneficiary cannot have any control over the trust funds. So the person who establishes the Able Act account has the signature authority. So a person with signature authority can administer an account for a designated beneficiary who is a minor or who lacks capacity to manage an account. So in the event that the beneficiary is not competent, anyone with signature authority can manage the account for the beneficiary's benefit. Signature authority does not equate to ownership. The designated beneficiary is always considered to be the owner for SSI purposes. And you're only limited to having one Able account wherever it's established. So who can establish an account? The eligible individual can, if he or she is competent. If not competent, or if the beneficiary is a minor, the account can be established by a parent, conservator, an agent under a power of attorney, or the individual's representative payee. Who can fund an Able Act account? Contributions can be made by any person or entity, including the eligible individual or a trust, such as a special needs trust. So there are some limitations with Able Act accounts. Currently, contributions are capped at the annual gift exclusion amount, which is $18,000 per year from all sources. However, if the beneficiary is employed, they can contribute up to an additional $14,580 per year. The Able Act account can be funded with up to $100,000 before it will suspend SSI benefits. If it gets over that amount, SSI benefits will resume once the Able Act account is spent down below that $100,000. The Able Act account can have up to $529,000 before it affects Medi-Cal eligibility. So distributions from an Able Act account are allowed for what they call qualified disability expenses. A qualified disability expense is essentially any expense that helps the individual with a disability maintain or improve health, independence, or quality of life. The categories are intentionally broad and include, education, housing, food, transportation, employment training, health and support services, financial services, legal services, and more. If money in the Able Act account is used for non-qualified disability expenses, the expenses will be subject to regular income taxes, plus a 10% penalty on account earnings. So the main benefits, funds in an Able Act account do not count as a resource for SSI, and qualified distributions do not count as income for SSI purposes. So to put this in the context of a special needs trust, arguably the greatest benefit of an Able Act account is that disbursements for food and shelter are considered qualified disability expenses and won't count as in-kind support and maintenance under SSI rules. So this makes Able Act accounts a great tool used in conjunction with the special needs trust. The special needs trust can make contributions to the Able Act account, and then the Able Act account can pay for food and shelter without negatively impacting the beneficiary's SSI benefits. So just some additional notes, contributions are not deductible. Earnings in the account grow tax-free, and distributions are tax and penalty-free if used for qualified disability expenses. Transfers from one Able account or program to another are allowed, as well as transfers to another family member if they are an eligible individual, as well as from a 529 account to an Able Act account. For Cal Able, there is a small annual maintenance fee of $37. You'll need to provide a minimum deposit of $25 to fund the account. You can link a bank account to transfer funds to and from the Cal Able account. You can also, compare Able Act programs through the ablenrc.org website, and you can open a Cal Able account at the website of calable.ca.gov. And with that, I'm finally going to turn it over to AJ to, wrap us up with talking about TrueLink cards.
All right. So final kind of brief topic here to conclude our presentation. I just want to have a couple of moments to discuss the TrueLink card. So in practical terms, there's always, issues of how do we provide funds to an individual who's receiving public benefits, SSI, Medi-Cal. It doesn't make sense to follow them around and pay for things directly. It doesn't make sense, obviously, to give that person cash. So, what are our options to provide or give somebody some, cash or the equivalent of that, give them some autonomy to use funds on their own and that sort of thing. And so the TrueLink card is, I think, a really good option that family members use, that trustees use, when it comes to providing that individual with some spending money for their needs, and they can use that card for things that benefit them. So the TrueLink card itself is this preloaded debit card that can really be customized and tailored to the specific beneficiary. And doing so, it gives the trustee or the parent control over how much is on the card, where the individual can use the card, and you can even block certain items being purchased from stores so the beneficiary can't buy alcohol and tobacco products, for example. So it really gives that individual, the trustee of a trust, for example, a lot of control over how the funds on the card are used, without giving the beneficiary cash, but also giving the beneficiary some autonomy on using the funds in a little bit more of a discretionary way. So that the Social Security Administration, their own rules specifically approve and authorize the TrueLink card, which is why we emphasize it and discuss in our presentations and with meetings with clients. So it's important that if this is set up, that it's done correctly, and we want to ensure if a trustee creates or sets up the TrueLink card, that the trustee or the parent, the third party, that person's the owner of the card, the owner of the account. The card will have the beneficiary's name on it, but it's that parent or that trustee who's really in charge of the account itself. If the card is set up, we want to ensure we block the ability to get cash back. We don't, exercise that option in setting up the card. That creates issues for income and resource problems, and so that's something that we want to avoid. And that's just, I think, clicking a box in the TrueLink card application process to avoid the beneficiary from using that card to get cash. And that's something that we want to make sure is done correctly. And then as long as the card isn't used for food and shelter expenses, the food issue, as I mentioned earlier, is going away. So that's probably going to have some more flexibility there. But as long as the card is used appropriately, and it's not going to be considered income, it's not going to be considered resource. And it's just, I think, a really good, efficient way to make distributions to a beneficiary. Next slide.
Do you mind if I add some things, AJ, about the TrueLink card?
Sure.
The TrueLink card is a great resource. We use it here. Just be aware that if the beneficiary goes to certain stores, like you allow Walmart or Target, you can buy alcohol there, right? It won't block that. It's not that specific. So just be aware of that. We also have beneficiary advocates who we will issue the card to for the benefit of the beneficiary, like a parent or somebody who's responsible, who's the beneficiary advocate, who can use the card and more responsibly, let's say. And then you can allow places like Walmart and Target and know that alcohol won't be purchased, that sort of thing. So I just wanted to add that about the card, but it's really good. And before it was very difficult to pay for expenses. You had to write checks all the time. So
Right, yeah, it made it, I think, a simple, more efficient process to make distributions for smaller items, provide some autonomy for that individual to go out and use the funds. I think it's still important for record keeping that your receipts are kept or sent to the trustee, for example, in case an agency wants to review how the card's being used. So I think that there's some considerations that go along with that. And if somebody isn't good with money, even though it's allowable by these agencies, sometimes it isn't necessarily a good idea to have that person have a card that they can go use things for, because there is concern of how it will be used, even with some of that control. So there's, I think, some practical considerations I think that Meredith was highlighting as well, when you're actually using this card and what that looks like in the real world. But I have meetings with clients, with parents. I say if it's something you're interested in doing, try setting that up and seeing how that goes, and not giving your child cash, because I often hear like they get SSI and I give them $200 a month in additional cash for spending money, and it's that's technically unearned income that has to get reported. So we want to avoid that, and the TrueLink card I think is a good balance between giving some spending deference, but also keeping some control and not impacting benefits at all. And then just the last slide, I think I kind of highlighted some of these things already in my discussion about it, but pretty easy to set up and use. It's pretty user friendly. It's approved by Social Security Administration, so that's been significant for us. Minimal monthly fees to have this card in effect. So it's I think a great tool that parents should consider during their lifetime to see how it goes. The TrueLink card is, I think, really accepted wherever Visa is accepted. So it's, you kind of have that peace of mind that it's not going to be rejected at certain stores. It's really kind of accepted everywhere. And I think it's just a good tool to keep in mind now and in the future. And I think just the approval from these agencies has made it something that's been, very beneficial, and I think some assurance and peace of mind that we can set this up appropriately and there won't be impacts on any of the benefits that we're trying to maintain. So with that, thank you for
We have a
listening.
question, AJ. Can we answer a question about TrueLink real quick?
Okay.
Okay. Can TrueLink limit the amount of food items that can be purchased for each visit? For example, one bag of chips limit, so can't purchase 20 bags. No, you can't do that. You can limit the amount of dollars at a certain store, but they can turn back around and do it again and buy, you can limit $20 at Walmart, and then they can buy the $20 and make another transaction of $20. So it can't be that specific. It's for more responsible beneficiaries who are going to use the card appropriately. You can block like everything on it, which we've done for some beneficiaries, except for, let's say, gas station, gas at the pump. So if you just only want them to use it for gas, you can do that. But so hopefully that answers your question. Okay, I'm sorry, I did not mean to interrupt you.
Yeah, no, it's very specific for each situation. So it just kind of depends on what's appropriate, and what the parent or trustee feels comfortable with, distributing. So it's hard to have a general, this is the best course of action, because it's so unique to each beneficiary. In some situations, it isn't appropriate at all. So that's also another consideration too.
Right. But now after the end of September, food is not going to be included anymore, so that'll be okay.
Right. And that kind of goes to like the ABLE Act account situation too, is like the benefit of using ABLE is to pay for food. Well, that's a little, more of a moot point, because you can pay for food directly in, I guess, October 1st.
Yeah. Okay. I don't have any more questions here. Anybody have any more questions? Okay. Okay, thank you, AJ and Bronson, for all of that really great information. And
of course. Thank you for having us.
Yeah.
Thank you for having us.
Your information's on the screen here, so anybody can reach out to either of you directly, right? With additional questions and.
Certainly. And Meredith, we will provide you a handout of the slides that you can share for anybody who desires. And yes, feel free to contact us if anybody has any questions after this presentation.
Yeah, and then, as I said, I will work on converting the video and posting it on the website under virtual seminars, so everybody can revisit it. Great. All right, right on time. Thanks, guys.
Perfect.
Okay. Thanks, everyone.
Thank you all.
Thank you.
Have a great day.
Bye.
Bye-bye.